Good day, Mr. Roland. I am Duncan, and I'll be advising you according to the situation that you have encountered lately. Let me start off by explaining you the relevant law first. According to Section 1, Subsection 1b of the Law of Property Act LPA 1925, provides that lease is a term of year and it exists as an estate, and therefore it becomes the proprietary interest. Section 205, Subsection 1, Sub-Roman 27 of the LPA 1925, which further elaborate the circumstances of the duration. Leases can be divided into legal lease and equitable lease. For purposes of formalities, there is only one distinction to draw, which is leases that more than 3 years and leases that less than 3 years. For the formality of leases that are less than 3 years, such a lease can be created by simple oral or written agreement. However, there are certain requirements that must be satisfied, which includes that lease must take effect in possession, and there must be a rent payable based on Section 54, Subsection 1 of the LPA 1925. Leases that more than 3 years must be by date, it must be signed, witnessed, and delivered, provided under Section 52, Subsection 1 of the LPA 1925. However, if formalities are not satisfied, it will merely be the equitable lease, and yet it still can be enforceable on equitable principle, which is equity looks on that as done which ought to be done. That was established in the case Walsh and Lonsdale. And the doctrine highlighted that when common law and equity are in conflict, the rules of equity should prevail. A lease is always difficult to define as there's still no adequate statutory definition even for today. Therefore, the court has established 3 characteristics of a lease which can be guided in the case of Street and Mountford. In this case, Mr. Street charged Mrs. Mountford a license fee to enter a license agreement that gave her exclusive possession and other tenant rights. Mr. Street argued that Mrs. Mountford did not have a lease and was not entitled to rent protection. It was held that Mrs. Mountford was granted lease and a lease proprietary interest can be assigned and binds futures on her. Firstly, there will be lease if exclusive possession is grounded by reference to the surrounding circumstances, the negotiation prior to the occupation, the nature of the property, and the actual mode of occupation. It is generally seen from 2 angles. The first angle is that the exclusory power which allows tenant has the ability to exclude others, even the landlord, from the land. The second angle is the power of immunity that allows tenants to have immunity from supervisory control. The second characteristic is determined period, which provides that lease must be for defined and certain period of time. The commencement date and the end date must be fixed and ascertainable and not ambiguous. In the case of Lash and Chandler, there was a tenancy that was fixed for the duration of the war, and it was deemed to be unascertainable. It was held that a leasehold rental agreement must clearly declare or be based on something that can be used to prove what the term implies when the lease commences. In another case of Prudential Assurance Co. Limited against London Residuary Body, LCC bought Mr. N's highway land and leased it back for £30 per year. Tenancy will continue until council needs the land for highway widening. LRB took over highway widening after LCC abandoned it. The other defendant brought the land from LRB after a quick notice. PNC said highway widening was the only method to determine the tenancy. It was held that uncertain term lease was void and the tenancy, possessions, and annual rent formed a yearly tenancy. The lease was correctly determined since the provision allowing occupancy only when highway widening required land contrasted with the periodic lease. Lastly, rent is defined as the consideration paid to the landlord by the tenant for the use of the demised premises. It will usually be in money, but also can be any form including benefits in kind. Section 205 subsection 1 sub-Roman 27 of the LPA 1925 sets out the definition of terms of year as with or without rent too. The only requirements to be qualified as a rent is the amount of rent must be capable of be ascertained with certainty. In the case of Bostock against Bryan, rent could not be equated with the requirement to pay electric bills. Consequently, the couple's weekly payment of €400 would be adequate to satisfy the first criteria of a lease. In the case of CH Bali Limited against Memorial Enterprise, it was held that rent is a contractual payment to a landlord for land usage, not an entity. However, it must be noted that the rent is not strictly a requirement, although it is a common characteristic. This can be seen in the case of Ashburn, Anstel, and Arnold, when it was stated that the reservation of rent is not necessary for creation of a tenancy. Despite this, majority of leases still include rent. There are 5 types of leases which are different in nature, particularly the duration of the lease, which concerns the portion of determinate period of the lease, including fixed-term leases, periodic leases, perpetually renewable leases, leases for life, marriage, and tenancy at will. The periodic lease can continue indefinitely, which means that it can exist periodically, for example yearly, weekly, and etc. The lease continues forever until notice of termination is given, which is based on the duration of the rent payment period as agreed by both parties. However, for year-to-year tenancy, the general rule at common law is that half a year's notice must be given, provided under Barrows against Morgan case, which landlord was entitled to serve the notice without the consent of the tenant. In the case of Javad and Arcu, it is possible to imply periodic lease in circumstances where a person in occupation while negotiating the lease, whether there's a rent payable or even if it's rent-free. Rent will usually be payable, but it does cease if rent not paid. Once rent is paid and accepted on regular basis, then periodic lease will be implied as provided under Wajir against Mount Kirtland case. Tenancy at will is an informal tenancy which is based on a consent to occupy. Usually this is in circumstance where the landlord allows someone to live on his property, so there is a consent to occupy. In the case of Hislop against Burns, the court held that it's very important to look at the intention of the parties when they are entering into the arrangement. In this case, the landlord allowed the occupant to stay there out of sympathy. Because of the fact that it is out of sympathy, there was not an intention to grant any form of lease. However, the terms will be that landlord can determine the tenancy whenever he wishes, and indeed, either party can determine at any time. Rent will usually be payable but does cease if rent is not paid. However, if the tenant occupied the property without the consent of the landlord, tenancy sufferance will arise. The tenant will become a trespasser, subject to the protection afforded by Protection from Eviction Act 1977. So let's move on to the issue of this case. The issue is that whether the lease is enforceable or not, and what kinds of leases are being in this case. At first, the agreement between you and Ricky, which required Ricky to pay 1 year in advance, but he was not able to pay in full amount, does not prevent it to be formalized as a legal lease, due to the fact that it satisfies the requirements under Section 54 subsection 2 of the LPA 1925. The contract was done in writing and signed by both parties, and Ricky was also being in the possession with the rent as well. Therefore, Ricky cannot argue that the contract is not satisfied. Based on the 3 elements in Street and Mulford, Ricky has possessed exclusive possession on the workshop that he rented for his motorcycle repair business. The second element is that during the discussion, it was supposed to be a year-to-year tenancy with the determinate period of 1 year. but it has become void based on Prudential Assurance Co. Limited against London Residuary Body case. The fact that he was only able to pay for 5 months rental had destroyed the original 1-year tenancy and created a brand new 5 months tenancy based on his possession and the rent payment. Therefore, 5 months is a lawful determinate period. Since Ricky was not able to pay the remaining rental, I will advise you to negotiate with Ricky, perhaps gives another kind of consideration in exchange for him to stay in the premises, and does not have to be monetary. It could be in the form of goods or services as long as it is quantifiable with certainty every month of a year as per Boston against Bryan case. Initially, the tenancies was intended to be a periodic lease with you, requiring Ricky to pay the rental 1 year in advance. The length of the tenancies was determined by the duration of rent payable and the possession of the tenant. Reference Prudential Assurance Co. Limited against London Residuary Body case, where the length set here is 1 year. However, since you agreed to accept Ricky's 5 months rent, it has now evolved into a tenancy at will. This implies that you consented to Ricky staying in the premises in this 5 months in accordance with the principle outlined in Hislop against Burns case. The consent was given when you agreed to accept the 5 months rent from him. If Ricky chooses not to pay the remaining rent or provide alternative consideration after the 5-month tenancy period, it will automatically come to an end. He must then decide whether to move out or continue by paying the rent. A potential challenge you may face is Ricky's insistence that the tenancy was intended to be a periodic lease as agreed at the contract commencement. He might argue that you cannot terminate the tenancy. However, you can defend yourself by pointing out that a periodic lease requires the tenant to pay rent regularly, and it must be accepted by the order on a regular basis, as established in the case Wajet against Mount Kirtland case. In the application, Ricky hasn't paid the full 1 year rental in advance. Moreover, based on Barrett against Modern case, you have the discretion to serve a notice to quit as you see fit. Another argument is Ricky Myers regarding periodic lease is that if you want to ask him to move out, you must give a minimum period of notice to quit, which is 6 months provided under general rule at common law. If there's no notice given, both parties can agree on a chosen date to end the tenancy provided under the feature of the lease. However, you can present a defense by highlighting that the initial 1 year contract is void and the tenancy has now transitioned into a tenancy at will. It will automatically cease if no rent or other consideration is provided. If Ricky continues to unlawfully occupy the premise, you can claim against him as a trespasser, as indicated under the Protection from Eviction Act 1977 due to the emergence of tenancy sufferance. In conclusion, the agreement between you and Ricky is a legal lease and it is a tenancy at will, therefore it is enforceable. Ricky has to give consideration in order to continue the tenancy, or else the tenancy will come to an end. He must then move out. I hope my advice will help you out. Thank you so much.